Right, okay, so good afternoon everyone and welcome to today's webinar. We're very pleased to welcome Sally Roth from the Financial Services Group Committee, who will be delivering this session today. So I'll shortly hand you over to her, but before I do so, I just wanted to say a few things. So firstly, for those of you who haven't attended one of our IOSH webinars, I'm Ben Pollard. I take care of all the technical aspects of these sessions, so if you have any problems, I should try to assist as best as I can. On your screen then, most likely located at the top left-hand side, you'll notice a small bar with some written options on them. These are chat and Q&A. If you have any technical issues or audio problems and you need to get a message to me at any point, please use the chat option. If you have any specific questions for Sally relating to the content of this session, please use the Q&A option and ask your questions here. We'll perform a Q&A at the end of Sally's presentation and we'll go through everything. We'll aim to tackle as many of those as possible, but if we do run out of time, Sally has agreed that she will provide written answers to any unanswered questions at the end of the session. One final thing is that the session is being recorded, so if for any reason you have any problems halfway through, you will be able to play this back later on, and I'll be sending out an email with all of the details following the webinar. So with all that said, I'm going to now hand you over to Sally, and I hope that you all enjoy the session.
Good afternoon, everybody. Thank you for joining today's seminar and webinar. I'm Sally Roth. I'm the partner and head of health and safety and environment at DAC Beechcroft. It's a specialist team of 28 regulatory lawyers advising cross-sector organisations on people, product and environment risk from 7 offices in England, Wales and Scotland. Today, there's a lot of content to today's seminar, so I will be running through some of the slides quite quickly, but as you've heard from Ben, you will have the opportunity to see the slides and also go back over the seminar at any time. As it's the 2nd anniversary tomorrow of the implementation of the definitive guidelines for health and safety, corporate manslaughter, food safety and hygiene offences, I've been asked to provide an update on what we've learned from the cases which have gone through the courts and the Court of Appeal so far, and to reflect on whether or not they've achieved their objectives of consistency and certainty for sentencing of health and safety offences, and to ensure that the fines handed down are sufficiently substantial to have a real economic impact which brings home to management and shareholders the need to comply with health and safety legislation. In the 12 months before the guidelines came into force, there were only 3 cases where organisations were sentenced to fines over £1 million. And those were cases which were dealt with once the guidelines had been drafted but not implemented. So it's fair to say that the judges had regard to the intent behind the guidelines. In Scotland, the guidelines are not strictly implemented or enforced, but the Court of Sessions has indicated that it's entirely appropriate for sentencing judges in Scotland to take the guidelines into account when looking at all the sentencing information they have available to them. But it's fair to say that in practice, there is a huge variation as to whether or not the guidelines are followed. In England and Wales, in the first year after the introduction of the guidelines, there were 19 fines over £1 million, and that includes 4 over £3 million. I anticipate that a lot of you on this call today will have a really good knowledge of how the sentencing guidelines work, but I thought it might be helpful for us to run very quickly through how the sentencing is approached. And the next few slides, as I say, I'm going to run through very quickly, but it does show you what the framework looks like. Guidelines provide a framework for sentencing judges to go through what is a 9-step process. And I've set out on the slide some of the key steps that the sentencing judges take into account. So the first step is to determine the offence category using the culpability and harm categories, which are set out in the tables, and we'll have a look at those in a moment. Step 2, having determined the offence category, the court is then required to identify the relevant table for the organisation, for the offender, and there are different tables for different sized organisations. And the court should focus on the organisation's turnover or equivalent, particularly in the case of public sector or charities, to reach a starting point for the fine, and then consider further adjustment in the category range to take account of aggravating and mitigating factors. Step 3 is the point at which the sentencing judge should step back and decide whether or not the fine that he has landed upon is proportionate to the overall means of the offender, and adjust upwards or downwards, having regard to the financial circumstances of the offender in the round. Step 4 is looking at any other issues that warrant adjustment. For example, it could be the local economy, whether or not the business has, the fine would impede the business's opportunity and need to to invest in health and safety issues, that sort of thing, and potentially on the employment of staff. And then there are a number of other procedural steps to include reduction for guilty plea, which the sentencing judge has to go through. So let's look at culpability. I've set out on the slide the various categories under culpability. It's fair to say that the health and safety executive in practice very often have a starting point of high culpability when they approach offending behaviours. And so those are the various categories. I'm not going to go any further on that slide, but set that out for you. You can see the various categories. Then harm is the next issue that has to be considered when deciding the offence category. So the assessment of harm is to identify the initial harm category. And that requires consideration of the seriousness of harm, which you can see across the top on the slide, against, and there are various levels of that, A, B and C, against then, before assigning the final harm category, then look at the likelihood, the risk of harm, and you see there's 3 categories along the vertical axis: high, medium and low. So, for example, if you're looking at an offence of exposure to asbestos, there's been an asbestos breach, the health and safety executive are likely to say there's level A, seriousness of harm, risk of death from mesothelioma, and they're also probably going to say that there's a high likelihood of harm, whereas defence lawyers will say low likelihood of harm because the offending behaviour itself is unlikely to expose persons to much more than a low likelihood of harm occurring. And then before assigning the final harm category, there's 2 further factors that need to be considered: the number of persons exposed to the risk of harm. The more persons who are exposed to the risk, the greater, and whether the offence was a significant cause of the actual offence. And so if one or both factors are present, the sentencing judge should consider moving up a harm category or moving up within the category range. As I said before, the next thing is to determine which size of business and which table the offending company should be dealt with, and you look at turnover on that: micro, small, medium and large, and very large businesses, organisations. As you can see, there's not a great deal of guidance in relation to very large, but we are going to look at how the courts in practice have sentenced very large businesses in a little while. And just by way of reminder, not a great deal of change in relation to aggravating and mitigating features from the previous position prior to the implementation of the sentencing guidelines. Pretty much the same aggravating and mitigating features that we've all been familiar with in relation to sentencing of health and safety offences. So those are the aggravating ones and the mitigating ones. I'm not going to spend very much more time on that. Then look at other factors. That's the step 3, stepping back. The sentencing judge has to step back and consider whether or not the proposed fine based on turnover is proportionate to the overall means of the offender. He's going to look at profitability, but is also balancing that with the need, as I said right at the outset, the objective, which is that the fine must be sufficiently substantial to have a real economic impact, which brings home to management and shareholders the need to comply with health and safety legislation. So that's a very, very quick whip through how in practice the sentencing judges will approach the framework for the sentencing of organisations using the definitive guidelines. I've set out on this next slide some of the household names who have been handed down fines of approaching and exceeding £1 million since February 2016. I'm now going to take you through some of the cases which have been sentenced since February 2016 and also look at some of the Court of Appeal decisions to highlight some of the issues which have arisen. So the first one I'm going to take you to is the case of Claxton Engineering Services. Now, the Claxton case arose out of an incident in January 2011 where 4 men were constructing a large steel structure as part of a foundation for a large pressure test facility at Claxton Engineering in Great Yarmouth. The structure itself weighed several tons and unfortunately it collapsed on 4 men who were pronounced dead at the scene. The Health and Safety Executive, during their investigation, found some serious flaws in the planning and monitoring of the project by Claxton, who were the client, Encompass Project Management, who were the principal contractor, and in particular its director, David Grucott. Claxton pleaded guilty to breach of Regulation 9 of the Construction Design and Management Regulations 2007, which is the regulation which requires the client to ensure that the CDMC is provided with all the health and safety information in the client's possession in relation to the project. And they were fined, Claxton were fined £500,000 and £100,000 in costs. And to give you a flavour of their turnover, they had a turnover of 27 million in 2014-2015. Encompass, who were the project managers and principal contractor, pleaded guilty as well to Section 3 of the Health and Safety at Work Act and were fined £200,000 with costs of £50,000. And the director, Grucott, pleaded guilty to Section 37 of the Health and Safety at Work Act, which is the section which says that a director or senior manager can be guilty of an offence where the organisation is guilty of an offence if the offence has been committed as a result of connivance, consent or neglect. And he was sentenced to 7.5 months in custody, suspended for 2 years, 200 hours community work to be completed in 12 months, and costs of £7,500. Going then into the retail sector, this is one which I think has seen quite a great deal of publicity. Case has been widely publicised, and the circumstances of this very significant accident arose from a very routine practice at Wilko's premises. They were using a 1.7 metre roll cage to move stock around. It's something that's incredibly usual and regular around the store. But unfortunately, the roll cage toppled over a ledge that was created when the lift didn't stop quite truly, and there was a lip between the lift and the floor. It fell onto a part-time employee who was doing her very best to manoeuvre it out of the door, crushing her beneath tins of paint. And she suffered very significant spinal injuries and unfortunately is now confined to using a wheelchair. The court heard that the cage was incorrectly loaded and that employees had not been provided with adequate supervision or training, essential requirements, on how to use the metal cages safely. Store had also failed to tailor a national generic risk assessment to reflect local requirements, and the company had also been warned by staff and engineers undertaking Lola examinations about the lift and not levelling it properly. And the fine for that company was £2.2 million. Looking then at KFC. KFC was fined earlier this year last year now, for two separate incidents. In the first incident, a 16-year-old boy sustained second-degree burns when hot gravy spilled over his hands and arms, and he removed it as he was taking it out of a microwave oven. In relation to the second incident, another worker sustained third-degree burns as she removed a gravy tub from a microwave. The workers did not have protective gloves in either incident, and the judge found that the burns occurred as a result of inadequate supervision and inadequate provision of safety equipment such as gauntlets. The company pleaded guilty for 2 breaches of the Section 2 of the Health and Safety at Work Act and received fines of £950,000 for the first incident and £150,000 for the second incident. And I suspect a number of you are thinking why the fine for the second offence was much less. Well, if we go back to the sentencing guidelines, one is required to look at the totality principle, to look at whether or not the total offence and the total fine is appropriate and proportionate. And so the sentencing judge is looking at the 2 offences together when he's looking at the overall impact on the business, just to check that it's aligned with its original objective around ensuring that the fine is appropriate, proportionate, and sends the appropriate message home to management and shareholders. The reason why I've selected the circumstances of Go Ahead London as something to talk to you about is because it looks at the management of contractors, and we have seen a number of cases over recent years where businesses have failed to manage contractors appropriately. So it's worth looking at the circumstances of these 2 cases. So let's look first at Go Ahead London. The circumstances of that case relate to an incident which occurred in May 2011. A worker was using a ladder to access the top of a fuel tank, and he fell almost 3 metres, sustaining fatal head injuries. Health and Safety Executive, as they always do, carried out their investigation and found that there had been a failure by the organisation to manage their contractors effectively, to ensure that they had conducted their work safely. The company Go Ahead London pleaded guilty to a breach of Section 3 of the Health and Safety at Work Act and was fined £600,000 together with the costs of £78,000. And it's worth noting that the turnover of Go Ahead London is £7.6 million. So a substantial fine for an organisation of that size. Take you next to Iceland. Now, the case of Iceland Foods is particularly interesting. We can earn quite a lot from Iceland because it's one of those cases which actually went to a trial. And in relation to the other cases, very often we just have the sentencing remarks available to us, or alternatively just the notes from the Health and Safety Executive and those which appear on their website. But in relation to this, we have the benefit of seeing what happened during the trial. So the circumstances of this particular case arise from an accident which occurred on the 28th of October 2013, when a contractor had visited the company store to replace some filters within an air conditioning unit located on a plant platform above a suspended ceiling, which was located in the store's warehouse. The contractor fell 3 meters from the platform and through a suspended ceiling and sustained fatal injuries. The company was prosecuted for breaches of Section 2 and Section 3 of the Health and Safety at Work Act on the following basis. Firstly, that there were no barriers in place to prevent falls from the platform. And secondly, that the area of the platform immediately in front of the access ladder was restricted. And thirdly, there were several tripping hazards in the area, including cabling and the fixing points for the ladder itself. The company had previously been warned to take the area out of use until suitable protective measures had been installed on the platform. Once the work had been carried out to the satisfaction of the investigating officer, the platform was put back into use in March 2014. The company was found not to have carried out a risk assessment to consider access to the platform, either by contractors or indeed by their own employees. Iceland argued that it had intended for a guardrail to be installed around the plant platform and had paid for one during refurbishment in June 2013. As its defence, it argued that it was entitled to rely upon a specialist contractor who carried out the work on the platform to identify the missing handrail. However, notwithstanding that argument that the handrail should have been identified by the contractors themselves, the company was convicted after a 3-week trial. So if we then look at the sentencing of Iceland, what can we learn from that? Well, the sentencing judge heard the mitigation put forward by Iceland in terms of full cooperation with the investigation, a lack of previous convictions, remedial measures that had been taken to prevent reoccurrence. The sentencing judge found, having looked at culpability, as we've looked at earlier, that it fell within medium culpability bracket, and that there was a high likelihood of level A harm, which meant that it fell within harm category 1, if we go back to the table that I showed you earlier. The company, in terms of its turnover, £2.7 billion, was a very large company. But the sentencing judge, for the purposes of assessing the fine under the sentencing guidelines, decided that it should stay within the large business category. The sentencing judge found a starting point of £1.3 million, and after giving some allowance for mitigation, a fine of £1.25 million was ordered for the breach of each of the Health and Safety at Work Act offences, resulting in total fines of £2.5 million and prosecution costs of £65,000. I think Iceland case is really interesting because it shows how in practice the sentencing judge looks at each of the various steps in the framework that they're obliged to go through. Now just take us on to a different type of organisation, now a public sector business organisation, London Borough of Havering Council. The circumstances of this case relate to an incident which goes back to March 2015, where an employee of the council sustained serious laceration just above his knee whilst using a petrol-driven cut-off saw to cut trees and branches. The blade became stuck, and as he tried to pull it free, the blade ran across the top of his left knee. During the course of the investigations, it was established that the blade which had been fitted was inappropriate. There'd been no risk assessment for using the saw and the blade, and also that the employee hadn't been provided with the operating manuals for the machine he was using and hadn't been provided with safety equipment. So some key issues there for the organisation to address in terms of managing its own health and safety. It might not come as a surprise to you, therefore, that the council pleaded guilty to breaches of Regulation 4.2 and 4.3 of the Provision and Work Equipment Regulations, which relate to the appropriateness of the equipment and the information that's provided to employees and the training given. And they received a fine of £500,000 together with costs of £8,240. Now this case went to the Court of Appeal because the council felt that it had been dealt with particularly harshly, and in particular that insufficient account had been taken of the fact that it was a public sector business. And you'll recall that the sentencing guidelines say that where a business is going to be affected or people are going to be affected by the adverse fine, then that should be taken into account. So what were the arguments on appeal? Well, it was argued that the fine itself was manifestly excessive, having regard to the sentencing guidelines, and that the courts, as I said, hadn't made a sufficiently large reduction to soften the impact that it would have on services to residents. Now, the organisation, the council, was unsuccessful on appeal in getting the fine reduced. One of the factors that I think was one of the reasons why it may not have been successful, and one of the reasons which I think we need to learn from as a result of looking at the Court of Appeal decision, is that there is a need to provide a great deal of evidence to support the reasons why there will be an impact on services to residents or budgets, etc. And it's not sufficient to say there will be a fine and as a result that will have an impact on residents and local services. There is a need to provide a great deal more information in relation to that and to evidence that in front of the courts. So I think that that's one of the things that comes out of the Havering Council case, is the need to produce evidence to show the impact and demonstrate the impact on the organisation and the locals who may be affected by the fine. The council also argued that the discount that should have been given should be one of at least 50%, because you'll recall that they would refer to the sentencing guidelines, which said that there should maybe in some circumstances a substantial discount. But the arguments that they gave were rejected by the Court of Appeal, who said that the guideline had been correctly applied and there was no authority for the suggestion that the substantial reduction was one of at least 50%. Again, another Court of Appeal decision. The reason why I've selected the next two cases, which are Tata Steel and Whirlpool, is because you'll recall that right at the beginning of my presentation, I referred to the fact that there's very little guidance available within the definitive guidelines in relation to how very large organisations should be sentenced. And both Tata and Whirlpool relate to the sentencing of very large organisations and also provide some guidance from the Court of Appeal. So what are the facts in relation to Tata Steel? So the Tata Steel prosecution related to two incidents, the first of which occurred in September 2014. In September 2014, an employee lost the middle and ring fingers on his left hand whilst trying to clear a blockage on machinery at the company's site in Corby, Northamptonshire. There was a second incident not long afterwards in February 2015, where another employee lost part of his little finger when his hand was caught in a lathe at the same plant. Both incidents were investigated by the Health and Safety Executive, who found that the machine guarding was inadequate. Company pleaded guilty to 2 breaches of the Section 2 of the Health and Safety at Work Act. After assessing culpability and harm category, judge then has to reach a starting point, as we've talked about before, based on the company's annual turnover before adjusting for aggravating and mitigating factors, with, as I said before, the largest category for companies being with a turnover of £50 million or more, and very little guidance in relation to very large companies. You'll see that I've set out on this next slide what the guideline says in relation to very large organisations. And the guidelines, however, also say, as again I've referred to previously, that the fine must be sufficiently substantial to have a real economic impact, which brings home to both management and shareholders the need to comply with health and safety legislation. So the sentencing judge, whilst having the tables in front of him to assist him with assessing the starting point in relation to fine, also has to have regard to the second bullet point on that slide, that it must be reasonably substantial. So what happened in relation to sentencing? Well, the sentencing judge concluded, insofar as culpability was concerned in relation to the second offence, that because there had been a prior incident and a prior service of an improvement notice, there should be high culpability for the second offence. Also concluded that that there was a level B harm risk and the high likelihood of harm, arriving at a harm category of 2. This, of course, is a very large organisation with a turnover of £4 billion. As I said before, we've only got the tables in place in relation to large organisations, and the starting point for a large organisation would be 1.1 million, with a range of 550,000 to 2.9 million pounds. And the judge in that case took a starting point of 2.4 million and then moved up a harm category to harm category 1 to reflect the turnover, and increased that then to 2.75 million pounds to bring home the message to management and shareholders. It was also given, an argument was also made that the parent company had suffered substantial losses over a period of time, and therefore there should be an adjustment in relation to the fine to reflect those losses. But the sentencing judge declined to do that. He declined to adjust the fine downwards. So after the reduction for the early guilty plea, the fine for the second offence was 1.8 million. For the first offence, sorry, it was 1.8 million, and the fine for the second offence was 185,000. Total fine 1.985 and costs of 22,500. Again, this case was appealed to the Court of Appeal on the following grounds. One, it should have been medium likelihood of harm. Secondly, the judge had made a mistake in moving up a harm category. Thirdly, that he had double counted by increasing the starting point from 2.4 to 2.75 million, and that he'd also made a mistake in failing to adjust downwards to reflect financial losses. So what happened in the Court of Appeal? Court of Appeal said that the judge should have categorised the second offence as one of medium likelihood of harm. So he made a mistake there in relation to the categorisation of culpability, that he was entitled to move up a harm category to reflect the fact that the company was judged by turnover. Was a very high turnover business indeed. There was no mistake in relation to increasing the starting points, and his reasoning behind that was that senior management had been inadequately focused on day-to-day safety. You'll recall that there was an argument that the resources of the parent company were such that they had recorded losses, and the judge said that it was appropriate to take into account, notwithstanding that the company had suffered losses, that this was a parent company with very substantial means overall, and that was the basis for him not making a downward adjustment in relation to the recorded losses. And then, given the correct categorisation of the second offence as medium likelihood, the starting point was £2 million, and the account of taking into account the early guilty plea, the appropriate fine was 1.315. I think the learning points in particular in relation to that is that if you put the parent company's resources into play, then the courts are going to have regard to them, notwithstanding that the definitive guidelines say that parent companies will only be, or linked organisations will only be taken into account in exceptional circumstances. Again, I think there's need to provide some significant evidence in relation to losses in order for the courts to take account of that when they do their step back exercise, because otherwise, given the very significant turnover of those businesses, the courts are likely to say that it's absolutely proportionate and appropriate in order to send the message home to managers and shareholders that the fine should be a very substantial one indeed. Let's look then very quickly, before I turn over to you for questions, in relation to Whirlpool. Whirlpool decision was very recent at the end of last year. The Whirlpool decision is really, really interesting for me because it relates to an organisation where there was a finding of low culpability and harm category 3, so right at the bottom end of scale in terms of culpability and also in relation to the harm itself. The circumstances are such that it arises out of an incident in March 2015 where a contractor fell from an elevated working platform and suffered fatal injuries when the overhead conveyor was activated by a separate maintenance team. There had been an awful lot of good work done by Whirlpool and the contractor ahead of the incident itself, and ahead of the works, and that there had been quite a lot of communications between them as to how the work was going to be carried out, and in terms of understanding, each business understanding the various risks. But it seems that the contractor had left the job that he was doing for a while, and then when he returned he failed to notify those others working on the conveyor from Whirlpool, that he was coming back to the job, and they, not knowing he was working there, started up the conveyor. The allegations and the breaches which were identified was that there wasn't a job-specific risk assessment required by the contractor, and the method statement and a method statement. They also found that there could have been a more detailed permit to work identifying the potential risks of work. But as I said, the judge found that this was a low culpability in harm category 3. The company had a turnover of 500 million, was determined to be a very large organisation for the purposes of the guidelines. And the sentencing judge adopted a starting point of 1.2 million before reducing it by 150,000 for mitigation factors, which were good character and remorse, and then the 1/3 off for the early guilty plea at the first opportunity. And the company was fined £700,000. Points on appeal were related to the starting point, deemed to be too high when compared to starting points and category ranges for large organisations, and also the failure of the sentencing judge to take into account relatively poor profitability when considering whether the fine was proportionate to the overall means. So what happened then at the Court of Appeal? Well, the Court of Appeal fell short of providing guidance as to how a very large organisation would be determined, and it specifically said that it didn't want to create an artificial boundary, so it didn't want to set some tramlines for future courts, but it said that the language of the guidelines suggested that a very large organisation is likely to be one which has turnover in multiples of £50 million. Court of Appeal also held that the sentencing judge had incorrectly applied step 3, which is the requirement to check whether the fine based on turnover is proportionate to the overall means. Whirlpool had shown a loss in its 2015 accounts, and the losses were attributable to 2 events. Firstly, it was attributable to a poor investment in a subsidiary company. And secondly, you may also all have heard in the media about the product recall affecting Whirlpool and its tumble dryers, and that had had an impact on its accounts. And the Court of Appeal concluded that notwithstanding those losses, the fine was sufficient to have a real economic impact, but was proportionate to the overall means of the organisation. So it didn't adjust the fine downwards to take account of those losses, notwithstanding those losses in those particular accounts. It's clear, I think, from the judgment, if you look at the judgment, and it is worth a read, that the reason why the fine wasn't reduced further in relation to losses was because culpability was low. And I think that was very much a determining factor. But if you look back a couple of years, if we turn the clock back a couple of years, I think you'll find that the fine would have been significantly lower a few years ago. So notwithstanding that the fine in this case was reduced, and I've set out on the slide the basis of the reduction, the fine is still significantly higher than it would have been pre-guidelines. Couple of cases, I'm not going to go through them in great detail, but I think it's worth noting. These are cases where there was no actual harm. SR UK is a situation where the safety valve had been installed incorrectly, and there was a failure to assess a new safety critical trip, and a fuel line hadn't been isolated. The company pleaded guilty to Regulation 4 of COMA, and notwithstanding the fact that there was no harm actually caused, received a significant fine of 1.65 million. Similar thing happened to weights. This related to carbon monoxide risk following some work carried out by a subcontractor. Notwithstanding that no serious ill health was caused, the companies involved in that particular incident were fined 640,000 and 30,000 each. So just to bring my presentation to a conclusion, first of all, I've set out on the slide the fact that fines have greatly increased since the implementation of the guidelines in February 2016. Certainly a significant rise over the last year, with fines rising from 38.8 to £69.9 million and an increase in the average fine. The next thing that I wanted to look at, just in terms of drawing everything together, is whether or not the guidelines have provided greater consistency and certainty in relation to sentencing. So can we predict more easily in relation to a large or a medium or a small business what the fine is likely to be once we've been furnished with details of the breach? Well, my conclusion, having looked at all of the cases that have been made available to us since the guidelines were implemented, is no. But I think that that's really because, as Lord Chief Justice Burnett says in the Whirlpool case, no two health and safety offences are the same. The circumstances of the offending, the nature of the business and their particular financial circumstances are so varied that it's very difficult, when you've got such wide brackets, to be able to put your finger on what the likely fine is going to be. And I do appreciate that that's particularly difficult for organisations who are prudently trying to make provision for fines, particularly if they're likely to be significant ahead of prosecution and sentencing. So final point really is to say that the increasing fines, it goes without saying, shows how important it is to businesses to ensure that they regularly review their health and safety policies and procedures and ensure that their risk assessments and method statements are in place. It's also important, if you are prosecuted for an offence, to ensure that you manage that investigation appropriately to try and minimise the risk of reputational damage and financial exposure to businesses, and make sure that you've got all the evidence you need in order to properly mitigate your case should it come to sentencing. So that's the end of my presentation, and I'll now hand over to Ben and we'll deal with some questions.
Okay, great. That was very informative. There's quite a lot of content in there as well, so I hope everyone enjoyed it. Just before we go on to some questions, I'm going to quickly launch a poll, which I would like you just to take a few minutes just to take some answers for, just some feedback on the session itself as a whole. So that'll appear on your screen. It should appear on your screen now. So if you could just take a few minutes to do that whilst we're going through the questions, that would be fantastic. I'll start with the first question that's come through. So this person has said that the RAF Red Arrows ejection seat accident, that occurred before the new sentencing guidelines came into force. So is it likely that the new guidelines will apply when the judge passes sentencing next month?
A very quick answer to that is yes. Notwithstanding that offences have occurred before the 1st of February 2016, the guidelines are implemented to all sentencing that takes place after that date. So a lot of the offences that we've seen over the last couple of years since February 2016 have in fact related to incidents and offences which have been committed before the 1st of February.
Okay, great. There's a question here with relation to the fines. So with regards to fines that are received, where do the funds actually go?
Okay, so unlike the invoices and the penalties which are paid under notices of contravention under the Fees for Intervention scheme, where the funds and the money collected goes to the Health and Safety Executive. Fines which are collected go right back into the Treasury's pocket, not into the Health and Safety Executive. So effectively to government.
Okay, we've actually there's one more question at the moment, so it's a bit possible that some more might come through. But this next question, I'm actually quite familiar with the story. Well, I read about it. So this person says that they believe that the owner of a takeaway shop once received a prison sentence as a result of a death due to a nut allergy.
Yes.
So in this case, the oil used was a cheaper brand and contained nuts. So the customer informed the staff of the allergy, but they still got something that contained nuts. So do you think that similar custodial sentences will be handed out for small takeaway premises and the likes?
The guidelines themselves provide a separate. Today I've really concentrated on how businesses are sentenced, but the guidelines provide for how individuals should be sentenced under the guidelines. So the guidelines set out how individuals should be dealt with, and they're a little bit further on in the sentencing guidelines, but you can see, and you'll remember from my first slide, which dealt with culpability, that I set out how culpability is looked at in relation to individuals. And that's on my slides, which will be available to you at the end. What I would mention is, at this stage, which I think it may be of interest, particularly into the person who's just asked the question, is that there is a consultation going on at the moment in relation to gross negligence manslaughter, and the sentencing guidelines which will be in place in relation to gross negligence manslaughter, and the levels of penalty in relation to those. It's suggested that they may well be significantly increased from the penalties that we're seeing at the moment. So longer terms of imprisonment for gross negligence manslaughter in relation to health and safety offences than what we're seeing at the moment. That's what's provided for. Those are in a consultation process at the moment, but we'll wait to see what the outcome is of that.
Okay, great. So there's another one here with regards to, so this person has said that let's say that 3 large construction companies form a joint venture for a large bespoke project. What factors influence whether the turnover for the actual joint venture project is used, or the 3 parent company combined turnover is used?
It's likely that the Health and Safety Executive will prosecute each individual business, and therefore each individual business's turnover will be taken into account. That's certainly what we're seeing in relation to other construction undertakings, is that each business is looked at separately.
Okay, great. With regards to the guidelines, how are these guidelines treated in Scotland and Northern Ireland? Are they seen as influential only, or have they been fully adopted into practice?
In relation to Northern Ireland, I can't say, because that's not an area in which I have jurisdiction, and I don't have any expertise in relation to Northern Ireland. But certainly insofar as Scotland is concerned, I'm aware that there have been a number of Court of Sessions cases, one most notably the British Telecom case, in which the sentencing guidelines were considered as to whether or not they had application. They don't have application in the same way as they do in England and Wales, but what was said in the British Telecom case is that they have influence, so that the sentencing judge can look at them to see whether or not, and look at the process, look at the turnover, look at the way in which they're dealt with, and see if that assists him in sentencing the company overall. I have to say that my experience is that some sentencing courts in Scotland take them into account, others don't at all. So there's no consistent practice.
Okay, great. I think that actually also answers one of the another question that was asked, so that covers that. There is a follow-up question from the same person. This one's asked, are case defences being modified to focus on the guidelines to align with the judgments, like as opposed to being a more open argument approach?
Yes. If what you're asking me is how do the health and safety executive approach this, they will set out in what used to be called a Friskies schedule, which is setting out their argument to the court as to how the judge should approach it. They are setting out their views in relation to culpability, harm, turnover, aggravating features, mitigating features, in the way that they have done in the past. They're setting those arguments out. What then happens is the defence puts in a response document to that, saying how it views culpability, harm, turnover, whether or not the parent company's account should be taken into account, all of those sorts of things. And in many cases, we reach agreement as to how the court should approach, but ultimately it's the judge's decision overall as to whether or not he accepts what has been agreed by the health and safety executive and the defence lawyers. But yes, there is quite a lot of discussion and negotiation which goes on between health and safety executive and defence lawyers as to how they see the offending behaviour going through the various steps under the definitive guidelines.
Excellent. Okay, the response to that was fantastic. Thank you. So I think you certainly covered what they wanted to hear. We've got another question here. So this person says that he's trying to convince employees to follow safety rules. Most do on the whole, but one or two fail. Are there cases where employees have been prosecuted for breaching safety rules?
Yes, absolutely. Yeah, a number of. It used to be very few and far between cases where the health and safety executive would bring prosecutions against individual employees who were below manager or senior manager level for breach of Section 7 of the Health and Safety at Work Act, which is the duty which employees owe to ensure that others are not affected by their actions and they're kept safe. But we are seeing more and more, we are seeing a few more. It would be an exaggeration to say that we're seeing lots more, but we're certainly seeing more investigations of individuals and more prosecutions.
Okay, great. So this person's asking about historic cases. So how are historic cases being identified? So he's particularly interested in healthcare cases of deaths following falls over 3 years ago. So how are these being identified and how are they being investigated after 3 years? Is it due to the cases remaining open due to the coroner's delays, or are they being opened retrospectively in line with public interest cases?
Okay, so in relation to historic cases, they would normally have been, or they should have been, reported under RIDDOR by the organisation, and the health and safety executive will then commence an investigation. It may be that the health and safety executive then postpone making a decision as to whether or not they're going to bring a prosecution for Health and Safety at Work Act offences pending an inquest if there is a fatality, and that can mean that there is a delay in those cases coming through to court to be prosecuted and sentenced. We're seeing that. Certainly there is in the Health and Safety Executive's business plan, they are making a commitment to ensure that, particularly in the case of fatalities, 90% are looked at, investigated, and a decision taken within 12 months, which would provide a significant improvement on current statistics.
Okay, great. We are slowly coming to the end of this session. We've got a few more questions, so we'll try and get through a few more, but it might be that we'll have to tackle some of these afterwards. So the next question that I've got here is, as a health and safety advisor working with small companies, so up to 10 employees, I'm trying to get the message across about the seriousness of the application of these guidelines. Is there a briefing paper available at all?
Yes, certainly I'm happy to share the slides and the contents of this this seminar. I think they're going to be available on YouTube, so it might be worth showing those to the owners of those businesses. But I think actually a face-to-face meeting talking to them about individual liability is as important as the impact on the organisation, because where you've got small businesses, very often you can identify someone who really is at the heart of that business and is making decisions around or failing to make decisions around health and safety. Those people are exposed to individual liability, either under Section 37 of the Act or potentially in gross negligence manslaughter. And as I said earlier, the sentencing guidelines, there are new sentencing guidelines being consulted upon in relation to gross negligence manslaughter, which carry significant prison sentences up to 12 years or more. And also there are prison sentences being imposed regularly. I think if we look back to one of my earlier case studies where the director had a custodial sentence, albeit suspended, Mr. Grucott, in relation to the Great Yarmouth case. So actually, if I was trying to take a message home to owners of small businesses and particularly directors, I'd talk about the individual liability and the risk of imprisonment, because I think that will probably scare the pants off them.
Okay, great. We'll just do one quick last question, and then what we'll have to do is the rest we'll have to put some written answers, which again I will supply to everyone along with the recording. So you will at least get those answers, just not right now, unfortunately. So the final question then is just from someone said, did you say that a conviction for a similar previous offence would be taken into account if an almost identical fatality takes place some years later?
Yes, absolutely. That's evidence of a previous conviction. Firstly, prevents you from using mitigation to say previous good character, no previous offences. So you don't get reduction in the fine to take account of that mitigation and your previous good behaviour. But also it is regarded as an aggravating feature. So if you have got previous convictions, and indeed improvement notices, notice of contravention in relation to relevant issues, so similar facts, then those are going to be taken into account as evidence of bad character when sentencing for the subsequent offence.
Excellent. Okay. Well, that is all we've got time for, really. So all that's really left me to say is, again, just that this has been recorded and a copy of the slides, as well as written answers to the remaining questions, will be supplied to you all. So I'll be emailing that out to you over the course of the next few days, so you will get a copy. Thank you very much, Sally, for coming in and delivering that session. Thank obviously to you all for listening and for your questions. I hope you found it informative and beneficial. And obviously, if you do have any further follow-up questions at all, you can email me in response to when I get in touch with you. So thank you all for listening, and I will be ending the meeting in the next couple of seconds. Thank you very much.
Thank you.